Welcome back, Attorney Steve Vondran, and we are talking in this video about 3 ways to get to punitive damages in California. This is under California Civil Code section 3294. Okay, so when you're a plaintiff in a lawsuit, let's say a negligence lawsuit, which is like a personal injury action or a financial elder abuse action or something like a right of publicity claim, any claim, it could be any claim, you're seeking as a plaintiff to maximize your damages. One way you plaintiffs typically try to do this is through seeking punitive damages. Now, this is where you're asking the jury, or if it's a judge sitting in the case, to award the punitive damages, the maximum amount you can get because you have been injured. Now, how do you get there? First of all, in what is punitive damages? Let's talk about that real quick before we jump on. Punitive damages are damages that are designed to punish a defendant who's a bad actor. It's designed to punish and deter. Those are the key words you want to remember. Punish a bad actor and deter them from future conduct. Now, it could be an individual, it could be a company, you could be suing officers and directors, but you're trying to send a message that this should never ever happen again. Punitive damages is the way to award and compensate for that. Now, under the California Civil Code, this is in your state court cases. There's 3 ways to get there under the Civil Code. One is fraud. Now, whenever you're showing fraud, and even for that matter, punitive damages, you're looking for that clear and convincing evidence of fraud, an intentional misrepresentation, saying things that simply aren't true, false statements of facts, things that are designed to trick. I had a client one time that said, he tricked me, he tricked me, he tricked me. And that was your intentional misrepresentation. That's what we were talking about. Another way to get fraud is concealment of a material fact. One way they talk about that is like a car. You go into a car dealership and they're rolling back the odometer. They're concealing the truth. Things like that could be sufficient to get you punitive damages, and intending to cause harm. So you're having these false statements or material omissions that were intended to cause harm. Okay, that's one way to get there, fraud. Okay, now as we say with fraud, you gotta allege it in your complaint with specificity. You wanna be very specific what your grounds are for the fraud. Okay, so that's fraud. Malice is the second way. A second way to get punitive damages in California is to allege and to show and prove malice by the defendant or defendants. What is malice? Malice is an intent to cause injury. This is malicious, okay? This is somebody that's just being malicious. As it says here, despicable acts of a defendant. What is despicable? Things that are despised by reasonable people. What's a reasonable person? Tell it to the jury. Hopefully they agree with you. So, despicable acts of a defendant, despised by reasonable people. And malice, willing and knowing disregard of the rights or safety of another. So despicable acts, knowing and willful disregards of the rights or the safety of another. Okay, so lots of things can be malicious. Things that are extreme and outrageous, things where you just go, holy cow, who would do that to another person? That's malicious. That's what you're looking for. Now, the final way, number 3 here, actually it's number 2 on my chart, but is oppression. Oppression, what is that? It's, again, despicable conduct of a defendant which causes cruel and unjust hardship in knowing disregard of the rights of others. So that may seem similar to malice. It may seem malicious. As you know the word oppressing, you're oppressing somebody, you're just squashing them and turning them into not even a human being anymore and causing cruel and unjust hardship. Okay, so that's a quick and dirty overview. This is general information, not legal advice, but this is information about punitive damages. If you have those facts in a complaint and you can allege them, sure, allege them, but you also need to go forth and prove it. The burden of proof is always on the plaintiff in a punitive damage action. Now, one more thing I'll say is, what amount could it be? It could be any amount. A jury could award $50 million, but that doesn't mean that it's going to hold up on appeal. If you get too high of a damage award, a defendant may argue that that violates due process. take it up on appeal, and that could be reduced on appeal. So the general rule to go by is that punitive damages should bear some relation to the actual loss, but then again, you have jury verdicts all over the place in dollar amounts. So as a plaintiff always shoots for the moon, okay? Hope that's helpful. Have a great day. If you like this video, give me a thumbs up, keeps me going. Give me some comments down below. Feel free to share this video on your social media sites. Thanks for listening. You got my website down there, attorneysteve.com. Take care.